That concludes our 10:30 docket.
Thank you, Mr. Sheehan. That I'll ask counsel in 125449, State of Kansas versus Adrian Zongker to please come forward.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Adrian Zongker. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, you will remember this case is a direct appeal from a first-degree murder conviction out of Sedgwick County. And the court will remember that the facts in this case, I think my colleague and I, there's no tremendous dispute about sort of the underlying facts of this case. In fact, a lot of it was on a surveillance video. And so I'm sure you watched that. Although the underlying facts were not particularly in dispute, what the appropriate conviction, if any, in this case was in significant dispute, as was or should have been the proper disposition of this case. Because I think it's also not particularly disputed that Mr. Zongker is profoundly mentally ill, and that profound mental illness is a significant contributor to this case. That, Your Honor, I'm intending today primarily to argue about the first 2 issues and submit the others on the brief. The court may have other directions for me.
And real quickly, can you just, since there's a lot of issues, when you say first 2 issues, what are you referring to?
So the sufficiency issue, issue number 1 and issue number 2, sufficiency issue and the failure to give a voluntary manslaughter instruction.
Okay, your issue, the issues that you raised as his counsel. In other words, you're calling 1 and 2.
Yes. On the first issue, Your Honor, I don't intend to take a lot of time. The issue is there's insufficient evidence to show premeditation in this case. Premeditation is an element of first-degree premeditated murder. This court has seen many of those kind of issues before. The standards of review are set forth correctly in our briefs. The thing that, as I was getting ready for argument, I was thinking about is a month and a half ago, I was here arguing a different case and waiting for my case, sitting out in the gallery, watching as you were arguing, as you were hearing argument in Dairy Green, a case where parties were arguing about whether first-degree murder, premeditated murder, and second-degree murder are the same thing, or vagueness argument. You've seen it. And they're making the argument in that case, taking a different angle at it maybe, and you'll issue your decision on that case. I just thought it was interesting at the time, and I actually reviewed the argument that, I mean, the court was asking some questions about, asking the prosecutor, well, what would it look like? What would it look like to have a case that was intentional but not premeditated? What would that case look like? And the prosecutor at that time was like, well, it's an impulse. If it was a pure impulse thing. And I remember because I knew this case was coming down the road. And I remember sitting out there going, well, I guess we'll find out. I guess we'll find out, because this seems to be the case where it's pure impulse. There's no motive other than the ones that we'll talk about here shortly, if that's a motive at all. And in this case, it seems to me that we should be able to articulate real world facts that you would say, this is premeditated, this is not premeditated, this is an intentional killing, but not premeditated. And if we can't articulate those real world facts, I tend to agree with my colleague before. I don't understand how these aren't the same thing, but I know the court will get to that. So I'll move on then more to the instructional issue in this case, which I think is substantial and really did undercut Mr. Zonker's ability to have his day in court, which is his requested instruction for voluntary manslaughter. And this court knows under 215404 that a charge of otherwise intentional murder can be reduced to to voluntary manslaughter. That's a very level 3 offense if there's a killing that occurs where a person is acting in either defense of self or defense of property when they have an honest but unreasonable belief that they're acting in that capacity. I don't think, my colleague will clarify for me if I'm wrong about this, I don't think that there's really a dispute that there was not evidence that Mr. Zonker honestly believed he was acting in defense of his property. His own words said that. The jail call that the prosecution put on indicated that to whatever extent Mr. Zonker had any motive, it was to defend his perception of defending his property. And if that's the case, that takes care of the honest part of it. The second part of it, and my colleague's argument is, but you have to actually be able to invoke that defense. And so my colleague cites the Scott Roeder case for this proposition, where Mr. Roeder, the person that killed George Tiller in Mr. Tiller's church, had argued that he should be able to try to argue this sort of voluntary manslaughter. And this court said no, because what Mr. Roeder did in that case wouldn't have qualified for self-defense, even if everything that Mr. Roeder believed was true. That wouldn't have qualified as self-defense, because Mr. Roeder's theory was, I needed to kill him because George Tiller was going to do some abortions the next day or sometime in the future. And this court said, well, that's not the way self-defense works in Kansas. You can't prospectively defend people in the future. So even if everything Mr. Roeder believed was true, you couldn't.
Isn't that true in this case also?
No, Your Honor. And that's the distinction, is the state, I guess, is arguing that you can never use deadly force in defense of property. And that's not true under Kansas law. There's two ways we know that. One, under 215225, which outlines defense of property, it says, doesn't have any limitation in there, except that the use of force has to be reasonable. And who would decide that? It would be a jury. The second way we know deadly force must be authorized in some cases is because it's included in the definition of voluntary manslaughter itself, that the person has an honest but unreasonable belief that they are acting under defense of self, defense of other, or 215225, defense of property. If it was never possible, if there was no, as a matter of law, you cannot use deadly force in defense of property, that wouldn't be in that section, because then it would be like Roeder.
Okay.
So it's our,
All right. My understanding of the voluntary manslaughter is that the perspective of how much force is necessary to defend the property in this case, person standard, as opposed to perspective of the defendant. Is that wrong? Are you, I guess, there's a perspective issue to voluntary manslaughter, and it seems like you're trying to say that we have to look through the lens of the defendant's eyes on that element, as opposed to an objective, reasonable person.
yeah, I mean, and I think Roeder tried, I think Roeder attempted and tried to sort of understand the intersection of those things, because it is to some extent through the eyes of that defendant. It's the honest belief that you're acting under this. And Roeder says, but okay, but assuming everything you believe is true subjectively, it still has to amount to that defense. So it's not just that you believe, it's not just this subjective belief that I thought what I was doing was lawful. That's not the test. It has to be that you honestly, believe that these facts were, but if that was objectively unreasonable, it still mitigates the murder to manslaughter. That's the whole point of that part of that statute, that you're not entitled to self-defense or defense of property for whatever reason, maybe because the use of force was unreasonable, but you honestly thought you were. And so the reasonableness of the amount of use of force at that point would be part of the jury question.
Would you concede that if, as a matter of law in Kansas, a person would never be justified in killing someone in defense of a bag of coins? Would you, if that was the law in Kansas, then this instruction would not be appropriate?
I'm sorry, I just didn't hear you're not, as a matter of law, not defended to use deadly force to defend what?
A bag of coins.
A bag of coins.
If that were the law in Kansas, it sounds to me like you're agreeing that your client would not have been entitled to this instruction.
Then that would be Roeder.
That's Roeder. Yeah, okay,
But that's not the law in Kansas.
right. Well,
And I would be surprised if, and I'm going to be surprised if this court says that in Kansas, as the Kansas legislature has set out the right to bear arms and the right to self-defense and the right to defense of property, that you can never use force or deadly force to defend property. That's not what the Kansas law says. And again, the best way we know that is the definition of voluntary manslaughter that we're talking about. Because if that was true, Justice Stegall, why would 215225 even be in that statute? It's not, it's completely incongruent. So it must be the case that there are some set of facts where a person can use even deadly force in defense of property. And if that's true, now, using the standard of review, viewed in light most favorable to my client, could any jury on these facts find voluntary? In fact, I don't even have, could one or more jurors have a reasonable doubt sufficient to lower this to voluntary manslaughter? If so, this is reversible error. And in fact, was the real crux of this case. My colleague says, well, even if it was error, it wouldn't be reversible error. I beg to differ, not surprisingly, that in fact, that seems to be what perfectly fits this case. That Mr. Roeder, because of his mental illness, because he processes reality differently, did he really believe he was in defending his property? That seems almost sure to me. And would a jury have found that, been given the option? Seems likely, if not almost certain.
And if we were to assume that that instruction was legally and factually appropriate in this case, how does that error interplay with the prosecutorial error in a cumulative error type of analysis? Can you kind of give me your best case as to how those might be interrelated,
Yeah.
if at all?
So, so if you find, and with time, you'll review the procedural error claims, I know. But to the extent that you find that certainly a lot of those errors went to state of mind of the defendant. Not directly, because my client was not allowed to argue that he was acting in defense of property. And so I guess the combination of those things, had he been allowed to argue for that he was at least honestly acting in defense of property and that should mitigate that you think about, well, some jurors might have believed that, one or more jurors might have believed that, one or more jurors, if the prosecutor hadn't erred in misstatements of fact and misstatement of law, might have said, we don't think it was premeditated. That when you put those things together, that is it less likely than that you had 12 jurors unanimously find my client guilty of premeditated first-degree murder? I think yes. So under cumulative error, and it certainly would contribute to that. My time is out, Your Honor.
May I ask one question? Does it make a difference that in 215225, it doesn't talk about deadly force, but it does in 5222, 215222, and 215223, and I guess 215224?
It doesn't, other than this, in the reverse, I mean, if the legislature wanted to say, here's the only times you can use deadly force in defense of property, they could have, because we know that they did in the other statutes. They didn't in that statute. They said it just has to be a reasonable use of force. And because there is no limit on that, we can look at the difference between those. If the legislature wanted to say, you can never use deadly force in defense of property, they could have. And we know they could have because we can look at the other statutes. Thank you, Your Honor.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll also focus on the first two issues and obviously answer any questions that you have on the remaining claims. As to issue one, there was some discussion by counsel about how mental illness was unquestionably a part of this case and how it clearly contributed to the act that the defendant committed here. Clearly, there was testimony that the defendant has been diagnosed with various mental illnesses. But what's telling is that the only witness who testified about the mental illness issue testified that the defendant, despite the mental illness, was not, that mental illness or those mental illnesses did not prevent this defendant from forming the intent to kill. And so I think it goes a bit far to suggest that there's no question that his mental illness is what directly led him to shoot the victim in this case. He didn't present any witnesses about his mental illnesses and how those might have affected his actions in this situation. It was just the state's witness who again testified that while yes, he has been diagnosed with mental illnesses, but that those did not affect his ability to form intent.
Well,
Now-
and I think it might have been you that was here a couple of months ago that I asked the question of what is the distinction, and please tell me what intentional murder isn't also premeditated. Give me examples of that, or how does that fit here? What are you relying on for this to be you said he has the capacity to form the intent. What else is there for premeditation?
Sure. I don't remember if that was my case, but I can certainly answer the question. I think that here what we have, I know counsel has indicated that this appears to be just a textbook case where it's an impulsive decision. And I'm sure that I understand to some extent that what he's relying on is how quickly the shooting itself happened. That he pulled the gun out and shot one shot, and that was the extent of the violent act. But when you look at the totality of what happened in this case, I would argue, and of course, we don't have to prove motive, but I disagree with counsel's assertion that this is not a case where there was some evidence that would show motive. Yes, the shooting happened in a matter of a second or two. But leading up to that, we had this defendant in the restaurant for a significant period of time. And he's not just in there sitting and eating his lunch. He is very agitatedly looking through both the booth where he had been sitting and then through the trash can. So he is clearly agitated. And then when you combine that with his statements to the psychiatrist, and I think also to law enforcement or on the jail calls, we know that in his mind, he believes that somebody has stolen something from him. He first mentions a receipt to the victim's wife. And then when she in fact provides him a receipt, he very quickly changes and says, no, I'm looking for this bag of coins that somebody here has stolen. So he's looking for that object frantically, going back and forth between the booth and the trash can. And then we see that when the owner, the victim, comes over initially to the trash can area to offer to help and get this trash and take it outside so that he can continue his search, we see that that's the point where he very clearly makes it a point to grab that clutch, which is where the gun was, and he takes that over with him to the trash area. And then as soon as the owner comes over and is in that area, he then makes sure to grab that back from the ledge that he had put it on so that he's now got it in his possession. So I think this is all evidence, circumstantial evidence, giving rise to the fact that he's upset. He thinks that somebody is responsible for stealing these coins. He's frustrated that he can't find them. He sees the owner coming over there, and even though the owner was coming to help, perhaps the victim didn't interpret it that way. So he makes sure to grab this clutch with the gun, and then they ultimately do go outside. He hasn't found what he's looking for. Several minutes have passed. And so, yes, while the ultimate shooting itself took a second, and he didn't fire 10 shots, he only fired one. But I think when you look at the totality of the evidence, it paints a picture that this was not something where it was just a spur of the moment thing where one instant he's not upset and then all of a sudden something triggers him, and without a chance to consciously think about his actions, he snaps. As far as the general question, what would be an example of a killing that is intentional but not premeditated? I think it would be something where there's no indication that the defendant is at all upset, and then all of a sudden, truly on the spur of the moment, something happens. I guess thinking purely hypothetically, let's say you have two people in a bar and there's surveillance footage showing that the defendant has not shown any anger or frustration the whole night. And then somebody bumps into him from behind and spills his drink on him, and he just instantly turns around, pulls out a gun and shoots that person one time. I think there it would at least be a stronger argument for a defendant that there was no time for him to consciously deliberate his actions, that he truly was just triggered and boom, without having time to think, he fires the shot.
Don't aren't we kind of putting the cart before the horse when we ask what facts are intentional versus premeditated? I mean, correct me if I'm wrong, but my understanding is that juries convict of first degree intentional all the time. Is that right?
Second degree intentional?
I'm sorry. Yes, second degree intentional.
Certainly so, yes.
So
Yeah.
those are all the cases that
Yes.
are intentional murder, that are not premeditated.
Yes. So yeah, exactly. There are plenty of cases where that is exactly what the juries have found. Some of those are cases that are charged as second intentional, and some are cases that are charged as premeditated, like this one. But the jury decides that, in their view, he's guilty of the lesser. So I think it's largely an academic exercise because we know for a fact that it does happen. And here they were instructed on intentional second, and they simply chose, and I set forth the factors, as did counsel in the briefing, the 5 factors that are generally looked at to determine whether something is premeditated. And, just going through those briefly here, the first factor is the nature of the weapon. Well, he used a semi-automatic pistol, about as deadly a weapon as you can get. And he fired that directly into the victim's chest from a few feet away. It wasn't like he shot him in the arm or shot him in the knee, or like he pulled out a less deadly weapon. He had a deadly weapon that he chose to pull, aim, and fire. There was absolutely no provocation. To the contrary, the victim was actually trying to help the defendant search through the trash for whatever it was that he was looking for. So this isn't something where we could say, well, he snapped because the victim did something to provoke him. The conduct before the killing, I've already addressed that. You see him agitatedly searching through the trash and through the booth. He resumed doing that right after the killing. And then I think you also have to look at the statements that he made to his parents on those jail calls very clearly. And I think the evidence is obvious in this case. We can all agree, looking at the video and just using common sense, that the victim, his wife, nobody in that restaurant had stolen anything from this defendant. But in his view, he thought that he was missing this coin, this bag of coins, and he was holding somebody responsible for that. And he even mentioned to the psychiatrist that he also acted out because he felt like he had been a victim his whole life and that it was time for him to stand up for himself. So while these are thoughts that are not something that any of us would presumably be able to understand or to relate to, he was going through a thought process here. He didn't say on those jail calls, I don't know why I did it. I snapped. I just lost my temper. I didn't have any time to think, and I regret doing it. No, he seemed to be saying, hey, somebody had to pay for this. Now, I'd acknowledge that there were no evidence of threats. He didn't say anything to threaten the victim, and that there were no additional blows after the gunshot. But I think when you look at the totality of the evidence here, and keep in mind the standard of review, that we're looking at this in the light most favorable to the state, and we're not reweighing evidence. We're not searching the record for ways that this could have been not premeditated. So looking at all of those things, our position is that the evidence was more than sufficient to support this conviction. Turning to the second issue, our position is that this very much is Roeder. That what Roeder tells us is that if it's a situation where even if the circumstances that defendant believes to be true exist, if those circumstances would not have justified the use of deadly force, then you're not entitled to this instruction. And again, this is a situation where we don't need to look to hypotheticals and try and figure out scenarios.
Can I interrupt you there and just drill
Sure.
in a little bit? The would not have justified, I understand the Roeder decision to be would not have justified as a matter of law, as opposed to would not have justified because not objectively reasonable. And it seems like you might be mushing those two things together. Am I wrong about that?
Well, I think in this case, I guess ultimately, whether it's as a matter of law or as a matter of fact, the end result is the same.
But it's not because, and this is defense counsel's argument, the whole point of this instruction and of voluntary manslaughter is to say that there's a lesser punishment when there's an honest belief that is not objectively reasonable. So you can't use the lack of objective reasonableness to say you don't get the instruction. It would have to truly be Roeder, where, as I was asking opposing counsel, as a matter of law, deadly force to defend a bag of coins could never be self-defense in Kansas.
But I think as the question of whether a lesser is warranted, there's always that factual component about whether the evidence in the light most favorable to the requesting party would have supported it on the facts of the individual case. And so here, while counsel's argument is that, well, the law seems to be that the legislature does believe that there might be some circumstances where you could use deadly force to defend property, I don't think we need to get there, because in this case, what we have is factually him saying that he was doing this because he thought some coins had been stolen. Now, as I note in the brief, he never says that he thinks that this particular victim is the one who took those coins. In the jail calls, he keeps using the word they.
So
They stole coins, or they took something.
is your argument actually that this instruction was not factually appropriate because there's simply no evidence of this honest belief that deadly force was needed to protect property?
I think,
Because he didn't even have the property.
right, of course. I think you can decide it that way. If you don't agree that this is this is Roeder, because you don't think that the law goes as far as
Is
saying.
that what
it isn't.
actually happened in the district court? I mean, is that the district court's actual ruling?
I don't think the district court, to my recollection, and counsel can certainly correct me if I'm wrong, I don't know that there was much specific discussion, certainly not about Roeder or that line of case.
It was just, I'm not giving this instruction.
That's my recollection. But again, yeah, we have a situation where A, this victim had not stolen the coins. B, even if he had, it wasn't like the defendant was using force to stop an ongoing, he wasn't trying to stop him in the act of taking the property. So I think on these facts, it would never be appropriate. You know, if I come home one day and I found that my home has been burglarized, and I suspect that my neighbor Dave is the one who did this, and then a week later, I see neighbor Dave at our mailboxes, I don't think that by any stretch, anybody would reasonably argue that then I would be entitled to use deadly force or entitled to an instruction on voluntary manslaughter because I'm using deadly force to defend property that I suspect had been stolen by this person hours, days, weeks, months earlier. Well, here we have a situation where, again, even believing the defendant's story that he actually thinks that this person that somebody had stolen these coins for him, you don't just get to enact vigilante justice and shoot a thief.
What would have happened if the judge would have said, you know, I'm going to, in light of our case law and what it says on the factual prong on lesser included, that, you know, if I can envision a scenario under the facts here where it would be justified to give the instruction, and gives the instruction, and the jury came back with a verdict for voluntary manslaughter, where would you be?
Yeah, I think.
I mean, would you be up here arguing that you would be saying, yeah, there's sufficient evidence, I would say. That's what we have here. That's our standard.
But I think the scary thing about that is that in that scenario on appeal, there's a very strong likelihood that the defendant would say, no, there isn't actually evidence to support that. And I was essentially convicted of a crime that I was not charged with and that there was no evidence for. And in that scenario, obviously the outcome is just flat out reversal. And there's not even an opportunity to retry. He was convicted of a crime that he was not charged with. So I don't know. It's always.
And I know I'm throwing out a scenario, but I think it's
Sure.
it's a very real scenario that could have happened here.
Sure. But I guess, you know, there's always that possibility that you could say, well, the instruction could be given because theoretically a jury might do something bizarre. And then would the state on appeal try to preserve that conviction if that was the situation that they were put in? And that's always such a fact-specific question that it's hard to answer as a hypothetical. But I don't think that that's a basis to say that an instruction should be given simply because there's a theoretical possibility that a jury could do something strange. I think there still has to be a realistic look at the evidence and say, okay, this person has given these various explanations for why he did what he did. He thinks somebody stole a bag of coins from him. He's mad at the world because he thinks he's been picked on. But the fact remains that at the time that he shot this person, the victim was standing there helping him look through the trash. Not have the coins, but even if he did, he was not in the process of doing anything, of stealing from him at the time. So under these facts, even if this court doesn't agree that maybe the Roeder case is on all fours with this case, the ultimate result is that the instruction was not warranted and therefore the district court did not err in declining to issue it. I see that I am also at my time. And I would submit the remaining arguments on the brief.
Very quickly, counsel, can you give us your state's position on the illegal sentence claim on count 2?
I think as to count 2, I think that was actually what I brought up myself in the briefing was that noticing. So yeah, I think there's.
In other words, there's no dispute that this was an illegal sentence.
Yeah, I think it's clear that there was this disparity between the journal entry, and I think the journal entry got it right, but that was not ever actually articulated in open court. And so, yeah, it clearly, the sentence that was pronounced in open court was based on an incorrect criminal history, and it would need to be resentenced on that. And as I said in the brief, I think it's maybe an open question on whether the defendant would be able to waive his right to appear at a resentencing, but one way or the other, that count does need to be resentenced. If there are no further questions, the state would respectfully request that the district courts, that the defendant's conviction be affirmed. Thank you.
Thank you, Your Honor. Justice Stiegel, I just wanted to respond to a couple of your questions to my colleague that, I mean, you're right. There are people in our state who are convicted of second-degree murder. But the question that this court and under this, the decisions that you're considering when you consider vagueness is it arbitrary? There has to be a reason. If you can't articulate a reason for why they do in one case and not another, that's vague. And you said it's not vague. So we should be able to articulate that. Like, here's the situation where, no, jury, you can't find that's premeditated. If you can't articulate that, I think it's difficult. The second one is, response is, the district court in this case said, well, I don't think there's any evidence that the gentleman stole anything. So it's not, and yeah, that's true. We're not denying that. That was the district court's error. That's not a requirement for voluntary manslaughter as we understand it under Kansas statutes.
Was there any evidence of an honestly held belief that deadly force was necessary to protect property?
Yeah, I mean, to me, that's the irony in our arguments, because I'm arguing there's no evidence of premeditation. My colleague is arguing there's tons of evidence of premeditation. I disagree with him about the interpretation of my client's physical affect because of his mental illness, but he's saying he did this because he thought the guy was stealing from him.
Well, but he thought the guy stole from him. In other words, is that evidence of an honest belief of the need for deadly force to protect property?
Yeah, my client believed, and there's evidence through his own words and actions that he thought he had coins on his bag. They found coins in his bag. This wasn't like he even made up the coins, although I don't know that would make a difference.
But
But
Justice
I'm saying
Stiegel-
as a matter of law, if you think someone stole from you and has the property with them, is killing them actually protecting the property, a defense of property?
It's interference. It's interference with your possession of your property. So yeah, if you came and stole my horse, Justice Stiegel, and you have my horse, I don't have to sit there and go, well, I guess you
I
got
think
my
it's
horse.
lawful in Kansas for someone to
To use
shoot
force,
a thief who has
Use force.
already absconded with the property.
to use force against a person who's interfering with my lawful possession of
Deadly
property,
force.
yes.
Okay.
That's exactly what 5225 says. And again, that would be a jury question about in a particular case, what the level of reasonableness would be. But viewed in light most favorable to my client then, for our purposes, should my client have been able to have his day in court on that? Justice Rosen, here's one difference between if a jury had come back with voluntary manslaughter, my client would have gotten a maximum of 98 months in prison. Instead, he's going to serve the rest of his life in prison under this current conviction and sentence. That's a pretty big difference, for which he never got a day in court. Thank you.
Thank you to both counsel for your arguments. The court will take this case under advisement.